So good evening all the participants and today's speaker CA Vasudevan. Very warm welcome to all of you to this series of international taxation. Today is the last day of this series and it has been a wonderful series covering all the aspects right from the filing of 15 CB certifications to transfer pricing, and now today we are on this topic of recent case laws and the litigation trends, which will be conducted by CA Vasudevan ji. I thank him for joining and accepting our invitation to be here. So before we begin, I'll just introduce today's speaker to all the participants. Vasudevan is a qualified chartered accountant as well as a lawyer from and he has graduated from the ILS Law College, Pune. He has a post-qualification experience of over 7 years. He is currently a tax manager at Globeview Advisors LLP, a boutique consulting firm focusing on providing tax-centric business advisory services, where he advises clients on transaction structuring, cross-border transactions, and corporate tax issues. Prior to Globeview Advisors, Vasudevan was associated with DMD Advocates, a leading law firm in India specializing in tax litigation. At DMD Advocates, he has represented various MNCs and large corporates in their direct tax matters before various fora, including the High Courts and Supreme Court of India, while also catering to various tax advisory assignments. He had his articleship with V. Shankar Iyer and Company, a leading CA firm in their Delhi office. He continued to work with them post-qualification till he started his study in law. He is also a profound speaker at various courses on taxation conducted by the ILS Law College, Pune. So, an excellent faculty for today, CA Vasudevan. I once again welcome you, sir, to this webinar and hand over the charge of the webinar to you. Over to you, sir. Thank you.
Thank you, Rishikesh, for the warm introduction. Very good evening, all the participants. It's indeed a privilege and a pleasure to be speaking at Pune ICI. And, like we say, it's always a pleasure to come back to your alma mater. And even though I did not do my CA from Pune, ICI as an institution remains close to my heart, and we all are directly associated with it. And I'm extremely happy to be here and to have got this opportunity to speak and rather discuss or interact with all of you on today's topic, which is around litigation trends in international tax. First of all, I think today marks the last day of this excellent course, having a very good lineup of topics and very eminent speakers who had spoken before me in the past 9 days. And it is rather, I must say, a matter of privilege for me to be, featuring somewhere with that list, and quite happy and thankful to Pune ICI for giving me this opportunity. On the session today, to start with, I would request, since we are well poised to have a good discussion on the topic, let us keep it interactive. And whenever anybody has got any doubt or any questions, I would request that you can raise your hands and probably we can unmute and speak. And I would be happy if we can make this interactive session so that both of us take the best out of this session, and I also get to learn, and I can share whatever small bit that I have read about this subject. Further on this topic per se, litigation trends and recent case laws, it is quite possible that a lot of these topics that I am going to look at has been somewhere or the other dealt with by other speakers in their respective topics, because they had a technical session which included various specific topics under the international tax. The topic for today is more generic, therefore it's quite possible, and it can entail all of those specific topics individually. So if you feel there is too much of overlapping and we need to slightly change or move forward, and something has already been dealt with in detail, then I probably would not get into it. Probably case law that I'm going to deal with, I would probably look at it in slightly but more detail to understand the transaction and the way it flows. Therefore, if you feel but it is already covered, then please let me know. I can probably go ahead. Uh, yeah, I can probably move to the next one, and we need not do what was already done. I would not like to burden anybody, with any kind of repetition. And I think today, since it's the last day again, like any last day of a college or a school, the topic is light. It's not going to be too technical on one specific aspect of international tax. It's going to be generic and a light topic. So hopefully we come up, or we have a good interactive session going forward. So I would present my screen. Just let me know if you are able to see the content. Is my screen visible?
Yeah, your screen is visible.
Sure. Thank you. And what I would do in case there is any Q&A or someone is raising hand, I would check it on a regular basis because I am presently looking at my screen. I would check it on a regular basis in between and then take it forward. So the overview of today's session broadly is going to be first to understand the litigation process uh, on the international tax side. Uh, I believe none of the other speakers in this lineup would have dealt with the litigation process per se. It was a session on different topics. So we'll broadly touch upon litigation process. It's not too different from the normal litigation, but nevertheless, we'll look at some specifics around the litigation process, and then we would get into some case laws. I have broadly categorized the case laws into 7 buckets. Not like we are going to see a lot of case laws under each of these buckets. In some of these buckets, there are just 1 or 2, but something which can give you a good perspective of the recent litigation position within these topics. So as we move forward, we'll look into these specific topics as well. So broadly, international tax, like you all know, it's the quite vast, but primarily it deals with interplay of taxation right between different countries, and which country has got taxation right on what income, and it involves cross-border transactions usually, and therefore it is a slightly different subject of taxation to read with. This interposing of two country exercising the taxation right is what is important under the international tax. Primarily, international tax concerns with two things. One is, or it addresses two things. One is the double taxation of income, which nobody wants, because the double taxation is something which will dissuade cross-border trade relations. Therefore, double taxation is something that countries would want to avoid. Then double non-taxation as well is something which is frowned upon. No country in the world, would want that, or maybe I would say some of the countries would definitely not prefer a double non-taxation where the taxpayer is earning money but is paying tax in no place at all. So in either of the countries wherever he is residing or moving to. So that is something which is again a concern of international tax. So usually, again, the problem or the issues under double taxation usually arises as an interplay of source rule and residence rule. This aspect you definitely would have seen in the other sessions also. Source rule is taxation based on where or in the country where the income is rising, and residence rule refers to taxation in the country where the where the person who's earning the income is residing. So both the countries have their own rationale to tax the income that the taxpayer or the person earning the income is earning. Therefore, the interplay of both of these is what is creating a large chunk of the international tax per se. Um, double non-taxation could arise because of abuse of treaty provisions. So broad subjects of international tax dispute. So when you look at any international tax dispute, broadly it deals with a few of these. One is for a foreign entity, of course, whether the income itself is taxable in India or not. That is one area of litigation. There is a substantive, the normal litigative course that we all are aware of. Then for a domestic entity, when it is making a payment to a foreign entity, whether the foreign entity was taxable and therefore there's a corresponding withholding tax obligations in India, which is under Section 195. So for domestic entity, that becomes aspect of litigation under the international tax realm. Another aspect which comes into fore is the disallowance of expenses under 40AI. So if there was a withholding tax obligation, but the withholding tax obligation has not been discharged, then the disallowance of the expense or the remittance that is made outside of India, which falls under 40AI. So this is another aspect of litigation. In a lot of cases, these are corollary, but uh, different. These are two aspects of the litigation per se. Then another aspect of international tax litigation is invocation of GAR. GAR is a domestic law principle. In treaty principle, now we have something called principal purpose test, which is for the broader concept than GAR. So in the international tax realm, again, that concept would gain a lot of importance. It has come by virtue of MLI. Prior to that, Indian GAR definitely covers international transactions as well, involving India somewhere. Therefore, having Indian tax nexus. Uh, so GAR definitely is important. Even that is now gaining a lot of traction as we move progress with GAR panel being set up, etc. Then you have transfer pricing, which you have already dealt with extensively. So I'm not going to get into the transfer pricing aspect. Then, or even my case laws do not per se deal with transfer pricing. And then the likely dispute which is going to arise in future is the equalization levy, which is definitely going to take uh, some kind of working. Though government is saying it is not a tax under the treaty, so it is not covered, but nevertheless it involves cross-border taxation. So, and the government might say it is not a direct tax at all, but broadly as a practitioner, we generally would consider as part of it's a direct tax practitioner who usually gets into this question. Therefore, the equalization levy is another important area. So the litigation process, broadly, all of you who are practicing might be well aware. When it comes to assessment, you have um, you know the assessing officer passes the initial assessment order. Then within 30 days, if you're aggrieved, you file an appeal before CIT appeal. Then within 60 days, if you're still aggrieved after the CIT appeal order, you file an appeal before ITAT. Even post ITAT, if you are aggrieved, go to High Court and Supreme Court, and uh, and it goes forward. Supreme Court is the last authority. ITAT is the last fact-finding authority. So there is one detour that is possible for international tax, not international tax case per se, but a case involving non-resident or a foreign company. This detour is possible is that you go to a dispute resolution panel after the assessing officer passes a draft assessment order. So so there is a mandate whenever there is a foreign company involved. there's a draft assessment order which is passed, and once and the SSC is allowed 30 days time to either accept and say this is okay, or he says that no, I will appeal before CIT appeal, or the third option is that I would take the matter before dispute resolution panel. If that be the case, you make an intimation to AO and file your case before the dispute resolution panel. Then the dispute resolution panel contains a panel of three commissioner of income tax. They decide your matter and pass their directions. So it is called a DRP directions, and those directions are given to the assessing officer to pass the final assessment order. And there has been recent case laws which confirm that the DRP direction has to be followed as it is by the AO. AO cannot make any change on the assessment or the DRP direction that is given. So the final assessment order has to be aligned with the DRP directions. Now, what has happened is that if DRP is allowing certain benefit, earlier the department had no remedy, the revenue had no remedy to file an appeal against the DRP directions. So, if the department or revenue is not aware or not agreeable to whatever is the ultimate findings of the DRP, uh, it is, what is notable here is initially there was a provision under which the appeal could have been done before ITAT by the revenue against DRP directions. Then this provision was removed, specifically because the logic was appropriate, because it's not even a final assessment order which is passed. Then how do you go to ITAT? And the final assessment order, by virtue of the law, it is passed by the assessing officer. He cannot question his own order per se. So this was a legal position which was there. So now what, in the recent budget, Finance Act 2023, what has happened is that there is no appeal mechanism even today, but there is a backdoor entry to which is allowed to the revenue, that they can file a cross appeal before the ITAT against DRP direction. So if the SSC files an appeal before ITAT against a DRP direction, now revenue also gets a chance to file a cross appeal before the ITAT. And it's well known that a cross appeal can have all those grounds which an appeal otherwise could have. So this is one recent change that has happened in terms of how the litigation process would move. So earlier, if a DRP gives you certain relief, the matter is closed. As far as that issue is concerned, the SSC never had to do anything further. The revenue could not do anything. But now the scenario has changed. Revenue still has a chance. So if there is as a strategy point, one has to now look at that if DRP is giving you a substantive relief and it has not allowed you relief on certain aspect, then whether you should go ahead before ITAT, because now the department gets a chance to file a cross objection. So this is one, from litigation point of view, this is one thing to be looked at. From DRP, you directly go to ITAT. So another benefit of this is that the route to ITAT became much faster. It got expedited, because otherwise from CIT appeal to ITAT, you never know when a CIT appeal order would get passed. There's no enforceable timeline per se, which was at least in practice. What was done is that DRP has a time bound process which is of 9 months. It cannot go beyond 9 months to pass an order from the date of filing. So therefore, the order got passed within 9 months, and you directly would go to ITAT. So the appellate process got really it got really expedited by virtue of the DRP process. Another aspect is when there is a withholding tax application. So if a payer is liable to deduct tax under section 195, and he proceeds to he kind of proceeds if he wants to make a remittance, and while making the remittance, the payer feels that there should not be any tax on this, or the tax rate should be lower, then he can approach the assessing officer and seek a rate wherein uh, a lower withholding tax rate would be allowed by the assessing officer. And this basically prevents you from any penal consequences subsequently. And it is a prima facie determination of what is a merit as well. So it is not conclusive, but at least a prima facie determination. So under 195, the payer himself can approach the tax officer and say that I'm about to make this payment, and this is a tax rate according to me as per law and DTAA. Please accordingly advise. And then they seek a certificate. Of course, they can be, the authority can agree or they disagree, but at least you make an application. And if they agree, then that is the rate that you follow. So for the specified some of the recipients, foreign banking company, etc., the application, it's the recipient, not the payer. The recipient can make an application under section 195(3). For a recipient, another route is section 197. There's a generic route. So this is not just specific for 195. It can be applied for even domestic law withholding sections as well. So 195 is a generic section which also includes 197 is a generic section which includes when there is a withholding cost or required under 195 as well. So even nil withholding, there is no bar. It usually says lower withholding, but nil withholding, there's no bar to go before the officer. But the downside of this route is that there is no appeal which is possible against the orders under 195 to 195(3) or 197. Suppose you ask for a rate of 5% on certain payments, 5% ADS, but the officer says no, 10% is a rate. Then you are bound by that rate and you have to apply TDS at 10%. Appeal is not possible. So in that case, the only route, you directly have to go from assessing officer level to High Court by way of a writ petition. In small cases, this might or might not be feasible. For large corporates, it's easier to go, in a writ petition. But a foreign entity might or might not want to get into all of this unless they know that there is a substantial, you know, uh, business that is yet to follow, and a determination by High Court will help them going forward. Otherwise, for a one-off transaction, etc., might not be so feasible. Of course, it's a faster resolution from High Court, and once you have it, it's easier on the merits. Subsequently, if there is a matter, if there is something that comes up, so only remedy which is possible other than writ petition is you file an application before CIT under section 264. So under 264, only a beneficial order can be passed by a CIT in favor of the SSC. But this becomes a ineffective remedy if, so invariably, if it's a decently large sum of money which is being, for which the application is sought for, when that happens, the application itself is processed and the order is passed after that the department has. And once the CIT is involved in the decision making process for 197 order, then CIT himself cannot now, you know, take the application under 264 and review it. So that becomes a ineffective remedy, essentially. Therefore, 264 might or might not be a effective remedy, uh, in a lot of cases. Then the only thing or the only remedy remains is you go before High Court in a writ petition. So, apart from this, there is another route of litigation or determination on a particular issue or a particular transaction, that you approach the board for advance ruling. So earlier this was authority for advance ruling, which was uh, constituted having certain retired High Court and Supreme Court judges, and the decision was by those judges along with a few members as a authority for advance ruling. But of late, it was noticed that it did not have sufficient strength. Why it was also quoted by one of the very senior tax official that usually the office bearers of authority for advance ruling would be a senior Supreme Court judge or a High Court Chief Justice. And when they decide a matter, after that, under the law, since there is no appeal, there is a writ remedy which is available. So invariably, if there is an advance ruling which goes against the SSC, the SSC would then uh, go to the High Court. Now, effectively, what is happening is that a Supreme Court judge deciding a matter is again being challenged before a High Court for determination. So, a lot of appointments did not come through because of this reason. And since the appointments did not come through, the matter, a lot of pendency was happening before the authority for advance ruling. So many matters went unresolved for more than 2 years, 3 years, which is effectively uh, rather it is very much negative to what or antithesis in a way to say as to what was sought to be achieved by authority for advance ruling. So before a transaction happens, if you want to take a ruling and if you have to wait for 2 to 3 years to do the transaction itself, then there is no use of such a you know or I wouldn't say there is no use, that would be wrong to say, but at least the effectiveness of the institution uh, is really, I think it is not appropriate, or it did not serve its purpose, for lack of correct word. Then now the government came up with board for advanced ruling. They replaced the authority for advanced ruling, and now it's a panel of two principal commissioners who would helm the affairs at board for advanced ruling, and they now would hear the matters. Generally, the applicant before advanced ruling, it includes non-residents as well, and resident who are undertaking transaction with non-resident. There are other applicants possible, but these are the relevant ones for us. And matters involves any transaction that is to be undertaken or proposed to be undertaken, and could be by a non-resident or a resident doing a transaction with a non-resident as well. And any question which is already pending before a tax authority, tribunal, or a court would not be decided by the board for advanced ruling, or if for that matter even AAR. And it involves if the question involves a FMV, if the question involves a FMV determination of a property, then even that is something that the authority would not get into. And if the transaction is designed for avoidance of tax, even that is not something that the authority would get into per se. So they would have to form a prima facie opinion that the transaction has been entered for avoidance of income tax, and then they would not give a ruling on that matter. And it is binding on the applicant and revenue. It's not a precedent in the strict sense. Like any other authority in India, if you have, say, ITAT, High Court, Supreme Court passing any order, it has a binding value on the lower authorities. But AAR ruling do not, or DR ruling do not have any binding value. It is binding only on the SSC and the tax authorities for that particular transaction. So that's the confined scope of the ruling. And there is no appellate remedy. Therefore, you have to go with writ petition. The effectiveness now is in serious question. With there's no outside of department. There's no determination. It's all within the department. Or determination is happening. So it's I think none of us can comment on what would be the effectiveness. It's on case to case basis. So let's then now jump into different case laws. At this point of time, I would just look at if uh, there's any doubt or questions. The Q&A box latest case law in favor of SSC for payment of FTS to UAE, treated as payment under Article 7. Yes, I do have not one but many case laws on this, Mr. Manoj. I would allude to that in some time. So there's a specific recent case law that has got relevance from that perspective, as well as from royalty perspective as well. So I would get to that question. So now the case law that we would look at primarily concerns application of MFN clause. This is recently uh, now the application of MFN clause has got a lot of I think it's been on discussion for some time now for that a Supreme Court bench has recently finished hearing a matter on application of MFN, and we are going to look at that case law and as to what that case law was about and what was the principle that was laid down. Now, per se, MFN clause basically. So the structure in the case law that I'm going to deal with, the way I would like to take it is that we look at the technical part or the legal part of it, and then we get into the case law so that we have a background, and then we move to the case law to understand it better. So an MFN clause per se is that whenever a treaty benefit is extended to a treaty partner on the basis of a treaty provision which is more beneficial and has been entered into with a third country. So imagine A enters into treaty with B with, say, royalty, for example, royalty at the rate of 10%. After the treaty between A and B, now A enters into treaty with C subsequently, and suppose uh, treaty between A and B provides that subsequently, if you enter into a treaty with another country which is a OECD member, so OECD membership is just one of the criteria. There can be multiple other criteria. And some of the MFN clause, there is no OECD membership also. It's generic. That is also there. Like for example, I think Philippines doesn't require OECD membership. So I'm just taking an example of OECD membership. Now, a treaty between A and B says if you enter into a treaty with C country or any other country which is a OECD member, and you allow a rate for XYZ nature of income, which is more beneficial than what you've allowed to me, then that beneficial rate will apply to my treaty provisions as well. So this is basically the MFN clause framework per se. So now, depending upon the language, this MFN clause can get triggered. It can get triggered automatically. It can get triggered on the basis of, it can be specific negotiation, renegotiation, which is required. It might also require a notification that we are now doing this. So the MFN clause is now applicable. So it's all dependent on the language of the MFN clause as to how it will get triggered. Then uh, I have listed down here in the table below those those clauses of MFN where a different nature or different action is required for application of that clause. For example, for Finland, you need an information notification. But for France, Netherlands, Hungary, Sweden, Spain, etc., you don't need you know you don't need any procedure to be followed. It's auto triggering. So since nothing is there, it is auto triggering. Otherwise, wherever it was intended to have one more step before applying the MFN, those were specifically provided for. Right? Yeah. Yes, Akshay, I think wherever countries, they do not require any specific action, the MFN is auto applicable. Now, for example, I have now taken out, culled out the provision from India Netherlands DTAA protocol. So the opening paragraph is this, that at the moment of signing the convention, with respect to taxes on income and on capital, this they concluded between Netherlands and India. Undersigned have agreed that the following provisions shall form an integral part of the convention. This is an important part, that on signing of protocol itself, it becomes a part of convention. So whatever is the treatment that you give to the convention, you have to give to the protocol as well. Now, within that, clause 4 basically provides for Article 10, 11, and 12, which is dividend interest royalty FTS. And if you see para 2, says if after the signature of this convention, under any convention agreement between India and a third state, which is a member of the OECD, India should limit its taxation at source on dividend interest, royalty, etc., to a rate lower or a scope more restricted than the rate or scope provided for in this convention, that is India Netherlands Convention, on the said items of income, if India agrees to a beneficial rate than this convention, then as from the date on which the relevant Indian convention or agreement enters into force, which is a third party convention, the same rate or scope as provided for in that convention or agreement on the said items of income shall also apply under this convention. So, as on this date, as on the date of notification of the third agreement, uh, that rate applies to the to the India Netherlands treaty as well. So this language directly says that on this day or on fulfilling of certain these conditions, the treaty benefit or the protocol benefit automatically applies. Right. So the language that way is very clear. Now, if we see what why the controversy really happened, that India entered into treaty with Netherlands, France, Swiss, etc. Long back. After that, somewhere in 1980s, 1990s. After that, India entered into DTAA with Slovenia, Lithuania, and Colombia. And in these treaties, it provided beneficial rate of taxation for income streams like dividend and interest. So I have given below the dividend rate. The dividend rate was quite beneficial in all of these, which is 5%. And here it is 5% with a condition of beneficial ownership. In Colombia, even that was not there. And why we would have agreed to a 5% rate is that if you see Slovenia, Lithuania, Colombia, it is more likely that we would be making a lot of investments in these countries rather than these countries making investment into India. So if we have a 5% rate applicable for them, then whatever is a dividend that Indian company would receive from them would have been taxable at 5%, which is, to my mind, would have been the reason for agreeing to this rate. And when India entered into DTAA with these countries, these were not even OECD members. So this was the date of entry into force. So when it was signed, and this was the date of notification of DTAA. So these DTAA came into force, say 2005, 13, and 14. Subsequently, these countries became member of OECD. So it is subsequent to India entering into treaty with these countries that these countries became member of OECD. Now, what has happened is that um, after these countries became members of OECD, um, there was notification issued by Netherlands, notification issued by France and Swiss government. Swiss government very recently. The other ones are slightly, in the past, and they said that since India has entered into DTAA with these countries, and these countries are now OECD members, the beneficial rate which is applicable under these treaties would now be applicable in the Netherlands treaty or French treaty or Swiss treaty respectively. And what has happened is that in this particular case that we have, that is Concentric Services Netherlands BV, there are more cases like this, Galderma and a few more, where these treaties were involved. Similar issues, similar problems. So I've taken Concentrix as something for our discussion. In this case, the Dutch parent received dividend from India. So like you see in the diagram, Concentric Netherlands had 99.99% investment in Concentrix India, and it received dividend back from Concentrix India. And on the dividend, the Netherlands DTAA rate is 10%. Whereas as per the MFN clause that we just discussed, the tax rate is only 5%. So what these entities did is that they went before the assessing officer, and before the assessing officer they made an application saying that withholding tax rate should be 5%, invoking the DTAA clause. But the tax authorities issued certificate only for the rate of 10%, and they did not agree at 5%. Now, under like the interpretation that these companies gave was purely based on the MFN clause. Now, for for the taxpayers, the matter after the withholding tax certificate was not issued at the required rate. The matter was taken to High Court on a writ petition. This was before Delhi High Court, and in the High Court, the the Council for Taxpayers argued that this MFN benefit is applicable and the lower rate automatically applies, etc. And the protocol was configured to be self-triggered, which we saw based on the language. It is possible and quite appreciable as to how it moved. But the arguments of the revenue is something which is important. It says that it would apply only uh, when the other country with which we have entered into DTAA is a member of OECD at the time of execution of the DTAA. We'll go through these and we'll go back to the clause and see how much this relates. Right. So MFN is applicable only if at the time of entering into DTAA with the third state, which is having beneficial rate, at the time of entering of the agreement, it should have been a member of OECD. And they said that these countries became member of OECD subsequent to DTAA rate. Therefore, and the lower rate was because in their own right, not because they were OECD members. So we did not give them the lower rate because they are OECD members. So other OECD members do not have any right to take benefit of that. And only when an amendment happens, because the MFN clause doesn't allow, the 5% rate can only happen with an amendment to Netherlands Treaty. Unless the Netherlands Treaty is amended, there cannot be any benefit which can be allowed. Then it should be, each country is free to choose when to become OECD membership, and because they have become OECD member now, India is not obliged to provide any tax benefit in this case. So now let us go back to this language which says, if after the signature of this convention, under any convention or agreement between India and a third state which is a member of the OECD. So the question is which is a member of the OECD, whether at the time of signature of the other convention it should be a member of OECD, or whether it should be on the date when you're applying the treaty. So imagine this, on the date of application of the treaty benefit, if you're reading this, that the agreement between India and a third state, which is a member, at the time of application of treaty benefit, yes, it is the third country is a member of OECD. Then India should limit its taxation at source on dividend, etc., etc., and that would apply. However, if you see the subsequent condition, that from the date of entering into force of the third treaty, the benefit automatically gets triggered in the first treaty, so treaty with the original country. Now, when India-Slovenia treaty was entered into, at that time, this benefit was not important. It was not possible that the benefit could have been taken. But subsequently, when they became OECD members, it was possible. So there is a time gap between the date of entering into treaty and they became OECD members. So whether can we still read that the OECD membership is fulfilled and the MFN is triggered. Now let us look at what is the findings of the court. So the court's finding, of course, against one of the arguments of the revenue, that there should be a separate notification of the protocol itself or the change in the protocol. And unless we notify the protocol, it cannot become part of or it you cannot take benefit. So this was then held in negative. The court said that there is no separate notification which is required because the language directly suggests protocol becomes an integral part of the convention. So as soon as protocol is signed, then it becomes part of convention because convention is already notified. There is no separate requirement. So there are a few more cases on this point, that is Tiria India and Polo Tires from Karnataka High Court, which also holds likewise. Then the condition for applying MFN benefit should be considered at the time of application by the taxpayer and not when the DTAA was entered into. So the language is a member. So if you go back here, which is a member of the OECD. So the department did harp on this, which is a member. The court held that you have to read is as a state of affairs at the time of application of the benefit and not at the time that the on the date of signing of DTAA this should have been fulfilled. So this was the so if you see the third point that basically gives out this. So at the time of benefit, yes, if the condition is fulfilled, you allow the treaty benefit. Then in addition to that, the reasoning which was given by the court is that they are adopting something called principle of common interpretation. So the principle of common interpretation, what they say is that when it comes to treaty where multiple countries are involved, then you have to have a consistent approach so that there is certainty and both the countries can have a better taxation system. So when this is the requirement, then we should follow common interpretation. Since the other country has already notified there is a decree uh, from Netherlands which says that a lower rate will be applied since the other country is already notified. And according to us also, it is possible to say that the benefit is allowable. Then we should follow that interpretation and go ahead with that. So these basically were the findings of the court, and they allowed the 5% rate, invoking the MFN clause. So other matters in High Court is this Nestle SA and Galderma. So what happened after this judgment is again slightly interesting and crucial. CBDT after this judgment issued a circular saying this unilateral decree given by any particular state does not bind India. It is not a shared understanding. The crux of DTAA and double taxation is that both the countries share particular understanding and both the countries come together, negotiate, and then give out the DT, then give out the provisions which govern the citizens of both the countries. Now it's a unilateral declaration or a decree. It does not represent shared understanding. Therefore, it should not be given weightage. So this is one aspect. In the CBDT circular, it was mentioned that therefore MFN should not apply because it's on the basis of decree or the foreign decree. Then date of entering of DTAA, these countries were not members, so therefore the benefit cannot be extended. This basically was, the argument that was taken before the High Court was then notified as, a circular saying these are necessary. Unless these are done, MFN benefit will not be allowed. So CBDT gave out this circular. Then it also said there is a requirement to domestically notify amendment to DTAA, etc., etc. So this one circular happened, and the matter from Concentrix, even Nestle, etc., all of those then went before the Supreme Court. The Supreme Court has heard the matter. A lot of councils have argued. By end of February, the matter was heard, and then 2 weeks time was allowed to file written submission. So by March, even the written submissions would have moved, and now the judgment can be expected anytime on this point. So this is the appeal number in case you want to check the status subsequently. So I've given the appeal number here. So other points that are to be noted is even the French government has given and Swiss government has given their own interpretation of MFN clause, and both of them have allowed a lower rate based on the treaty with Slovenia, Lithuania, and Colombia. But what is further more interesting is that the CBDT circular, which said that MFN clause is not automatic and it requires fulfillment of these 3-4 conditions, that has been overruled. And interestingly, ITIT Pune in 2 cases has done this. They have given reference to these 2 here in the citation, and they have said that it is auto triggering, and you cannot now, especially the notification part, that even if MFN is not specifically notified, if the language suggests that it should be auto triggered, it will be auto triggered. And CBDT, like, there are multiple cases. Circular is not binding on the SSE or the ITAT, it is binding only on the tax department. So that is what was finally held. So in these subsequent cases, so the last one, Trigo SAS, is as recent as 2 weeks back, that they have said we do not go by this circular that is issued by CBDT. So this was on the MFN. I'll just save this example for second clause. Okay. Akshay, which is the second clause that you are referring to? I'll go back to is this can you unmute and speak, Akshay? Okay, so I've already covered it. All right. Fine. So any other questions till now, or should we go ahead? All right. So we proceed with the next. So next is, it's a cluster of case laws, but these are important. Like we all know, engineering analysis center of excellence case by Supreme Court. It marked a watershed moment in the taxation for software sale, software transfer, software licensing. So on the software licensing part, it was a vexed issue, and a lot of case law was going on, and all of us, even the software that we were buying was then subject to tax in India. And so the Indian tax being one, and the royalty between the foreign supplier and Indian distributor itself was in question. So that was a huge matter with exemplified ramifications, and that finally was decided by the Supreme Court in 2021. Very fortunately, I had a chance to be involved somewhere in a small manner in this matter. So then, when this matter was heard, it did give out some very important principles, and it is not new. So I will just very briefly touch upon this aspect uh, as to what was held in the Supreme Court in engineering analysis. But my matter of discussion is not engineering analysis, but the application of the principle which was laid out in the engineering analysis. Just a few interesting examples as to where all this case was applied. So broadly, before the Supreme Court in engineering analysis case, what was considered as a taxability on these four categories which I've listed out. So when you purchase a computer software directly, the end user purchases, who's a resident in India from a foreign non-resident supplier, what happens to the taxation at that point of time? And when Indian resident company is a distributor or reseller, he purchases software from foreign country and then resells the same to resident Indian end users. So this was category number two. Then distributor itself is a foreign entity. So foreign distributor purchases the software from a non-resident vendor. So the seller of the software is a foreigner or of non-resident. The reseller of the software or a distributor is also non-resident, but they sold the software to a Indian distributor or end user directly. So there is one. So from the first category, third category basically interposes another distributor in between. And then the fourth is when a software is affixed to a hardware, like it could be like a medical equipment where there's a software involved and there is also hardware. And when they are sold as an integrated unit by a non-resident supplier to resident Indian distributor or end user, what is the taxability at that point of time? So broadly, these were the criteria, these were the categories which the court was looking at. And at the end, the answer to all of this was same. So broadly, let's look at the definition of royalty. We'll go into this technical aspect and then, because it is important, then we'll get into engineering analysis finding in subsequent cases. So royalty, if you look at the domestic law provision, it says transfer of any, all or any right in respect of a copyright. So this copyright, in respect of a copyright, if you are transferring any or all right, including granting of license. So I'm just reading the important part. And then with respect to computer software, it was specifically clarified that transfer of any or any right, all or any right in respect of any right, property or information includes or has always included transfer of all or any right or use or right to use a computer software. So irrespective of the medium through which such right is transferred. So computer software, with respect to that, any transfer of all or any right in respect of the computer software is would amount to royalty. So this is the gist of or the effect of this this explanation which was added. So there was a retrospective amendment of this explanation starting from 1976. So what happened is that any software sale became taxable under the Indian Income Tax Act by virtue of the amendment here. However, wherever DTAA benefit was possible and allowed, the language in the DTAA became relevant because the language in DTAA was narrower than what was the language in the domestic law provision, which basically stated that payments of any kind received as a consideration for the use of or the right to use any copyright. So when it is for the use of a copyright or right to use any copyright, then only it becomes royalty. So the other portion I'm not getting into. Computer software falls within the realm of copyright because it is considered as a literary work under the Copyright Act. So now, when it comes to only the copyright aspect, uh, copyright is not same as copyrighted article. So copyright contains bundle of rights, which includes, say, for example, copying, reproducing, giving further copies, creating multiple copies, etc. So when you are giving right to use copyright, Right to use copyright means having right to use any of these rights. It's only then that a payment would fall under royalty. Otherwise, it would not fall under royalty. So it is the language. The difference is in respect of a copyright is what is used in the domestic law, but here it is for use of any copyright itself. The copyright has to be transferred somewhere. Otherwise, there is no royalty payment. So this is basically ultimately what the interpretation of the Supreme Court was, so which I have listed down here, and a few others which is relevant in the international tax regime per se, is that when DTAA is beneficial, that will override the provisions of the Act. Then what is defined in the DTAA, then you should look at the definition there only. So if royalty is defined, then you look at royalty definition under the DTAA. You cannot go to definition under the Act. In the absence of definition in the DTAA, you go to definition under the Act, right? And under 195, what is only chargeable to tax in India, to that extent only you deduct any tax, not beyond. And in all of these cases, the end user license agreement specifically prohibited reproduction, reverse engineering, etc. Which, these rights indeed were the copyrights, to reproduce, to change, to modify, and then to sell it off. So all of those were copyrights, and those copyrights were specifically barred. Therefore, the court held that what is transferred is a right. So what is transferred is a copyrighted article, but not the copyright itself. The example that was given by the court. So a lot of, actually it was suggested by lawyers, and ultimately it came up in the order. A very, very important or a very good example is that when you buy a book, the content of the book is copyright protected. What you are getting is a copyrighted article because the book contains a copyrighted content. You cannot you can read through everything. You can probably even gain the knowledge which is given in the book, but you cannot reproduce it. You cannot make copies. You cannot sell it. You cannot do anything with the book except than to read. So you can only have take the utility from that copyrighted article, but you cannot exercise the right that a owner would have because you do not have the copyright. So this is how the court said that you should look at software also. You can utilize the software. Whatever is the utility of the software, you are free to use it. Just because you are utilizing the software for whatever utility it is, does not mean that you are having a copyright in that product. So if you are not having a copyright, then what you are paying is not royalty. It's a simple fees, or it's a business income for the person who's selling. So that's the interpretation broadly which was taken by the Supreme Court. And the definition of copyright says it gives certain rights. Unless you transfer it, you cannot say that there's a copyright which is transferred. And the OECD commentary, also another aspect that was provided is that OECD commentary can be referred as an aid to interpretation of DTAA. So there's been a lot of debate whether OECD commentary can be relied upon or cannot be relied upon. It can be relied upon is what Supreme Court held in this case. So in all of those scenarios, that we saw, the four scenarios, it was considered as not a royalty. So what happened post engineering analysis, how it is applied now, is something that we are going to see. I have taken 3 cases where the engineering analysis uh, principle is applied and slightly different interpretations in different cases. So we'll just look into. So this is a very recent case of Google. So last year, so there's one more case, which was very recent where they have applied the same principle. So so there is Google Ireland, then there's Google India. Google Ireland basically uh, provides uh, distribution right of something called AdWords program. So there's Google AdWords program. So this AdWords program was created by Google USA. Google USA then licensed out completely the Google AdWords program to Google Ireland for any sale which is happening outside of USA. So within USA, all the rights are with Google USA. Outside of USA, if you are making any sale, any advertisement, etc., everything is with Google Ireland. Now, Google Ireland, what it did is that it licensed out or it allowed the distribution rights of Google AdWords program to Google India. Okay, so what is a Google AdWords program? It is a software. Uh, so this program is accessible to you, me, everybody for free. There is no charge for using Google AdWords program. Under this program, what you can do is that you can create an ad. This program will guide you how to create an advertisement for yourself. You can create an advertisement, post it or upload it on the Google platform, and Google will then review it, all the AdWords. So 94% of review happens by the system. 6%, the advertisement is reviewed by Google manually. So that also is divided between 5-6 offices across the world. So in different parts of the world, your ad can go to anybody. So there is no demarcation, India ka ad, India mein chalega. Nothing like that. And now what happened is that this AdWords program uh, basically gives you a space where you can in the Google Ireland server where you can upload your ad. You do not know where it is stored, exact location, any control, nothing is there with you, but you can upload it on Google Ireland's server. Now there is no charge for this. Only when a user goes and clicks your ad on the Google website that you will have to pay the charges to Google India or Google Ireland. Now, what happened is that this purchase of space that was required, uh, Google Ireland broadly has all this space. And from there, what it did is the Google India would purchase certain amount of space from Google Ireland and sell it out to other Indian advertisers. So if I'm an Indian advertiser, I can either approach Google India, say I am uploading this ad which was created by AdWords, and I can upload it, or I can directly deal with Google Ireland and upload it. The payment, if I want to pay in INR, I can transact with Google India because that's a safe medium. If I am okay paying with USD or any other foreign currency, I can directly deal with Google Ireland. There is no problem. So it's a non-exclusive distribution. So distribution agreement. Google India can do what otherwise Google Ireland can do, and vice versa. Now Google India purchased all these um, ad spaces and it sold to Indian customers. Now the question came is that this Google AdWords program that you are giving out to people, whether the payment for it, so for the ads, etc., whether the payment, because the ad payment is for AdWord program, that is what people are paying for. Now whether the payment is a royalty or it is not a royalty. So this was basically the question that came up before the assessing officer. The assessing officer held that it is a royalty for all of these reasons, that there is a distribution right, which in itself was held as a IP right by the AO. The distribution right is a IP right and you are giving it, therefore it becomes royalty. So all of these, most of it were considered under the Domestic Act. And SSC has been granted license to sell or make, offer to sell, etc. Therefore, this license to sell or offer to sell AdWords is a copyright. So which could have been a possible interpretation prior to engineering analysis by virtue of say some Karnataka High Court judgment, which held it otherwise. So this was possible. Then right to use trademark, other brand features also provided. Then the process as to how the AdWord works and the marketing and distribution works is told to Google India. Therefore, there is royalty. What Google India is paying to Ireland is basically for the process. So all of these were something that was um, held by the assessing officer. And under Article 12 also, it says right to use copyright. Therefore, it becomes taxable. CIT appeal confirmed that there is royalty, but his thought process was that there is a right to use trademark and copyright, therefore it is a royalty. It did not say that there is any equipment which was allowed. So the AO, if you see second last point, said that the server where it is stored, it's a commercial equipment, and Google India has got access to those servers which is running AdWords, therefore it's a equipment royalty. The equipment royalty is one aspect of the royalty per se. So it becomes equipment royalty, therefore it should be considered as royalty. That CIT appeal did not upheld, but he is upheld royalty per se. Then what tribunal told is that it's a computerized advertisement program. So ultimately, it might be whatever the complexity, just see what is the product. It's Google AdWords program and it's a computer software. It might not be a software which you download on your system, but it is a software which is running on some platform and you are able to gain certain utility out of it. So it's a software program which is running on a server and anybody can use it. You create an advertisement, etc. And the Indian customer can purchase the ad space where they put their ad, etc. by using the Google AdWord program. And then advertiser, what was given to Google India or anybody was just, you know, just you can utilize the program. Nobody gave the intellectual property in the program. How the program was created, it was not given to either Google India or the customer. Or the copyright, nobody has now got the right to reproduce or recreate that software, etc. So none of the copyright in the AdWord program was ever allowed to anybody, including Google India. Therefore, even if the payment was made by Google India or the end user, but the payment is not a royalty per se. So therefore, because it is not for any copyright, so then they looked at the case law from the engineering analysis case law and held that unless you transfer copyright, there is no royalty. Therefore, the transaction is not taxable as royalty. But in such a scenario, now EL applies. So all of us know equalization levy was considered as Google tax because it applies on advertising transaction. So EL now applies on advertising transaction. It is not taxable as royalty. Yeah. So that was one case. I'll just see if there's any. Yeah. So Bhakti ma'am has got a query. Engineering analysis case vendor is non-resident and such not applicable for case where software purchased from resident. Kind of hardship. Yeah. So when you purchase it from a resident, whether you take it as a business income or you take it as a royalty, it's all taxable in the hands of the resident. So the question arises whether why the royalty question happened was whether something becomes taxable or not. Because if it is not a royalty, then it is business income. Business income, unless there is a P, uh, there is no tax in India. So the whole question came up because of the taxability and non-taxability issue. With the Indian seller, you anyways will have the Indian seller will pay taxes on the income that he is earning. He is liable to pay taxes in India unless he has got certain exemption, which will not bother any purchaser. Therefore, this question really did not, come up, or this question might not have a lot of relevance per se. Yeah. Would cloud charges amount to equipment royalty? No, sir. Actually, Simran, sorry. It would not amount to equipment royalty. There are case laws to this, like EPRSS from Pune Tribunal itself is there. Rackspace from Rackspace is there from uh, Mumbai Tribunal. So Rackspace, multiple case laws are there, and then there is now recent from after engineering analysis. There is one case law from ITT Bangalore, Urban Ladder Home Decor, that also looks at cloud charges. cloud charges were even earlier, before engineering analysis also, was not considered as equipment royalty, because the logic behind that was that whenever so what happens in cloud is that you get a you get you know you get some server space. You get a server space, there is equipment, you can say, but you do not have control of which place. So if you look at the DTAA and OECD commentary specifically said that uh, the payer should have control of the equipment. So unless and until I can control that equipment, I cannot say it's a royalty. So now control is established by me having the right to decide what is to be done with that equipment. When you take a cloud space, you cannot have any right to say the where the data is to be stored. Within the storage space, how will you identify where is your data? You do not have right to deal with it. You do not maintain the server space at all. It's some other party, and you simply pay for it. You have no control. Since there is no control, it does not become an equipment royalty. So this was the logic prior to engineering analysis. Now with engineering analysis also, it will remain the same, because even more, it becomes further strong that there will not be an equipment royalty. Uh, urban ladder home decor, I think that is a case law from ITT Bangalore. I can probably give you the citation at the end of the session. I would have it. So yes, I've noted down. I'll give you at the end of the session. Yeah. So, so this basically the case law that we saw for Google is something that affirms that it's not only. So what was there before Supreme Court was shrink wrap software. You get a proper CD based software. That was the case before Supreme Court. Even if it is not a case which is, you are getting a CD or so, even without that, today the medium could be anything. Today you do not have softwares coming in CD. You simply click a button, it gets downloaded in your system directly. Even with that scenario, there is nothing stopping you from applying the principles which was laid down in the Supreme Court, laid down by the Supreme Court. So the next case precisely, also deals with this point. So what happened? So on the Google, there's one more point that there was a agency P scenario also. The same, not in the same case, but on similar point, different case, similar fact pattern, different case. We will deal with that a bit later. Yeah. So coming to this case, EY Global Services. So what happened is that in a gist, if I have to tell you, there were multiple suppliers, software suppliers. From all of those software suppliers, EY Global, which is in UK, it sourced all the softwares from different parties across the world. Is a centralized sourcing, and this software was then made available to all the network EY network firms, and these EY network firm could access any of those software, like for example MS Office. Then you have some other server, some other generic, like for example Teams. So it's a centralized sourcing and everybody is able to use it. So this kind of arrangement was made, and EY Global entered into an agreement to provide support services. So in the name of support services, this enabling of common information technology and communication system was, it was arranged kind of, and then EY Global UK would maintain all of these, right? So sourcing point is same, maintenance point is same, usage is with all the network EY network firm. Now EY GPS India, it's not EY India, the auditing one that I'm referring to. I'm not sure how the structure functions, but EY GPS India also, which provides back office support in data processing. It also entered into this agreement with EY Global UK and made certain payments. Now, it was held by the AAR that what you're giving is that it's a benefit of computer software procured from several third-party vendors. And since you are giving the benefit of computer software, it becomes royalty in the nature of Article 13. So for this, AAR considered or applied uh, one of the ruling which ultimately got overturned by the Supreme Court, Citrix system, I guess. So that got overturned by the Supreme Court. So they applied that case law and they held that it was a royalty, and it is on account of provision of services, but it is not FTS. So that was held clear by the AAR that it's not a FTS transaction per se. And what was created is a standard facility, and it is allowing access to all EY firms and charging them based on the number of users, right? And all of these softwares are loaded on EY Global server, and from that server, everybody was given access to. Why I'm mentioning this is that there is one contrasting, like I would say, similar facts, but a contrasting judgment from ITIT Pune, which is just following. So this is a crucial fact pattern. Then, it is since you are creating a standard facility for commercial exploitation, it becomes royalty. I could not understand what was the logic of this, but yes, it was then held as a royalty ultimately. What the High Court held, this was before Delhi High Court, in a writ petition against AAR, what the High Court held is that on reading of engineering analysis, you have to show transfer of copyright in the software. So even if I source a lot of softwares, as a person who's sourcing it, I might not have the copyright in the software itself. So when I'm not having a copyright in the software, how would I really give the copyright to somebody else? So since I do not have and I'm not passing on the copyright in the software, it is not a royalty. So in the since there is no copyright, there is no royalty. This was primarily what was held by the Delhi High Court. So what was important is that the law laid down by Supreme Court, though it dealt with just four scenarios envisaged in that case, it has laid down the law for general application. So the High Court specifically now gave out the principle that even so nobody can distinguish engineering analysis saying it is applicable only on those four scenarios. It can be applied to other scenarios as well, and that is possible. So the contrasting ruling came in the case of Descartes Industries from ITIT Pune. So similar to what was there in EY, there's a Belgium firm, NV Descartes SA. It would negotiate global framework contract for IT services. So in this case, it was primarily SAP. So SAP was taken and the corresponding, the infra around SAP was created by NV Descartes, Belgium. And this IT infra which was created was then allowed to other group entities, and they were charged on the basis of number of users, whatever is the module in this overall, because SAP is based on multiple modules, whatever is the module that they are using, etc. All of that was the basis of charging the cost, and this was done along with markup. So what the tribunal ultimately held is that the payment is for IT infra. So the whole IT infrastructure which is set up by NV Descartes. So I would like to believe that the setup that they are referring is analogous to the setup which EY also did. And but in the EY case, it was held as not royalty. Here, surprisingly, what the not surprisingly, there must be there is a reason which is given, which probably I do not maybe one can distinguish, is that they held that it is IT infra, therefore it's a equipment. It's in the nature of equipment. The whole infrastructure is a equipment, and equipment royalty is covered under section 912 clause 4a, the explanation, and therefore it is a case of royalty. This was held, and there they also looked at the clear language in the act, which says that irrespective of whether the payer has possession or control of the property, it will become a royalty. But where probably I would beg to differ is that they simply held the language of the industrial royalty under DTAA is same as what is there in the 916. Yes, it is same, except the specific clarification which was there in the act, which says irrespective of the possession or control of the property. This language is not there in the DTAA. So when this language is not there in the DTAA, we have to apply the test of control and possession. So when the test of control and possession is satisfied, then it becomes a royalty. There is no doubt about it. Of course, there can be question as to whether all the softwares and the corresponding hardware, etc., put together becomes an infrastructure. Maybe the differing point is the hardware also being created. Uh, but even in EY case or otherwise, you would have a specified hardware to take care of all the softwares. So that would have been the case. Nevertheless, it is taken as an industrial royalty and they have gone ahead with the case. Similar cases, Rater Machine Works. If you want to refer, I have given the citation for that as well. So this was again what they specifically also held is that engineering analysis applies only on software royalty and it does not apply on industrial royalty. So this is a distinguishing point for which I specifically wanted to get into this case and speak about it. So these were some cases which happened post engineering analysis. Now we get into the question that was asked as to what is the taxability when there is, which Mr. Manoj did check earlier. So what happens if there's no FTS clause? So what happens if there's no FTS clause is that so it happens that in some of the DTAAs there is no FTS. The FTS clause is missing. And the examples basically are UAE, Greece, Mauritius. In these DTAA, you will not find FTS clause. The clause only is about royalty. So the usual Article 12 or 13. In these cases is only about royalty. So there are two views possible. One is that you consider this as a business profit, which falls under Article 7, and then apply Article 7, say that there is no P in, if there is no P in India, you say there is no P in India, therefore no taxability under Article 7. But there is just one ruling that I could find, which says that if there is no DTAA, there is no mention of this income in the DTAA, then that means there is no DTAA benefit that is allowed. So therefore, you have to look at the provisions under the Act. And then, so I've given the citation for that. For the business profit, there are multiple citations. So Mr. Manoj, this is what I was referring to. There are multiple. And what is most recent of all of this is one Ahmedabad tribunal case in Kalpataru power transmission, so which we will now look into what was the scenario. So there was an Indian company, and there was the Indian company had a branch in Uganda. The Uganda branch basically carried out EPC contracts outside of India. So the Indian company itself, which is Kalpataru Power Transmission itself, was engaged in carrying out EPC transactions outside of India. And the Uganda branch had certain projects. For Uganda branch, some services from UAE company was taken. So it was tower designing, structural drawing, etc. And UAE company provided certain services to the Uganda branch of Indian company. So why branch is relevant is that ultimate taxability will happen in India. It's not a separate entity in Uganda. Then the question would not have arisen that whether it's taxable in India or not. But it's only a branch, so taxability lies with Indian company. So UAE company provides services to Uganda branch. In turn, Indian company pays the fees for this transaction to UAE company. So at the time of paying the fees, the question is whether the transaction is taxable as royalty or FTS or what. So what is the taxability? Because taxability is important for 195 TDS. So this broadly what happened with the AO. So when the Indian company approached the tax officer asking for a TDS certificate, what was ultimately seen was that the TDS officer held that payment is for structural design. So design is one of the aspect of intellectual property and royalty. Therefore, since you are paying for structural design, what you're paying is royalty, and it is not an FTS. And royalty is covered under the treaty, and there is a rate provided, and it becomes taxable, and you therefore pay the tax. And he also gave the finding that drawing of tar. So there is contradiction here. So TDS officer said that the tar drawing that is being prepared by the UAE company, UAE company has a right on it. So service provider has a copyright on that design or on that drawing. So that was the finding of AO, whereas CIT appeal gives a contrary finding. But he also says that it is not a royalty because there is no existing design. So I'm not like having multiple designs and I'm giving you one of the design on which I have a copyright. That is not the case. Uh, so you engage me to create a design, and I create a design and give it to you. So it is a pure service transaction. Therefore, there was no existing design, and it was created, as a service by the UAE entity to the Uganda branch. Therefore, it's a service agreement. It's not a royalty agreement, and it's the ultimate customer who had the ownership of the design. So. You're preparing, so as a service, you create the design and leave the ownership with the person who has engaged you. So it's a pure service transaction, which was held by the CIT appeal. Since it's a technical service clause is not there in India UAE, it goes under Article 7. There is no P in India for the UAE entity, therefore, no tax payable in India. So this was a logical conclusion that was held by CIT appeal. But before the ITAT, it followed through. So they said that CAT appeals finding the transaction is one of service and not royalty is appropriate since it's a new design being created for the client. It's not existing design. And in so this is in this case for for what was held and the fact how it moved is relevant from royalty perspective as well. So when you are looking at taxability from royalty perspective, what you need to see is this. So if there is a case where you create a design as a service and not holding copyright etc., then it does not amount to royalty as well. So even if there is a FTS clause in a given, if there is a FTS clause, of course, it could become an FTS, but it is not a royalty. Something is very clear. And since in India UAE no FTS clause was there, it went out of the realm of taxation. So this is a recent case law on FTS clause not being there and taxability follows through. So these are some of the cases. So yeah, this is another important aspect of treaty based taxation. So there are certain payments under the treaty which are taxable on actual payment. Yeah, so this is the relevant. So this is something that we will look into. So there are transaction which is taxable on actual payment. All of us would know royalty, interest, etc. being taxable, but this is taxable on actual payment basis is something which is evident from the TTAA language. So like as I would definitely like to read it, that it is taxable on payment basis. So just see this language. This is under India US TTAA. It says interest arising in a contracting state and paid to a resident of the other contracting state may be taxed in that other state. So if it's an interest which is arising in India and is paid to a resident of US may be taxed in the other state is in the US or in India as well. So now and paid basically here means actual payment or whether it means even accrual and actual payment is not necessary. So Similar language, occurs for DTAA clauses on royalty FTS. So in a lot of cases, this is the actual clause. Therefore, one can always say when it is a interest royalty FTS transaction, though there is a taxability. So royalty FTS in most cases you will see there is taxability to both the countries, and what they agree is only the rate at which a transaction should be taxable. So when that happens, uh, whether can we say that only at the time of actual payment that we are required to do TDS? So under 195, we know that the TDS is required on credit or actual payment, whichever is earlier. But if you apply the treaty provision, which will override, by virtue of Section 90, which will override the domestic law provision, can we say that what we are providing for, uh, you know, if it is royalty or FTS or interest, depending upon the language, we will deduct TDS at the time of actual payment, and 195 should be applied on actual payment, and we need not do TDS at the time of credit itself. So this is one argument, and I'll tell you there are multiple case laws which supports this argument. So I have listed down at least I think 7 or 8 of you are left. So I ran out of the slide space. So I have listed out a few case laws. One of it basically gives uh, the gist of it is that when conditions of accrual as also the payment are to be satisfied for taxability of royalty and FTS. So something might have accrued, but until you make the payment, you do not tax it in India, and until you do not tax it, you do not deduct TDS. So because 195 says amount chargeable for tax. So these were some set of case laws. Now what has happened is that now there is a controversy which is created by virtue of a special bench reference. In the special bench reference, in the case of Ampaset Cyprus Limited, the division bench said that all this while we have been saying paid, uh, and arising and paid means actual payment. Now the word paid is not defined under the DTAA. So we just saw if something is not defined under the DTAA, you go back to domestic law provision. So under the domestic law provision, if you see section 43(2), which defines paid, which means actually paid or incurred. So incurring means credit, incurred according to the method of accounting. So actually paid or incurred also is considered as paid. Then the the treaty language basically should mean that even credit or actual payment, whichever is earlier. So even under the treaty, this would be the treatment. But one of the thought that I can have with my limited knowledge is that the language is arising and paid. So arising would refer to accrual of income, and arising and paid means the dual condition of accrual as well as payment. Both are necessary. But what is surprising is that there is a Bombay High Court judgment. So on top, if you see Siemens, so there's a Bombay High Court judgment which allows a payment basis taxation on royalty. In spite of that, can there be a reference? So the matter has been heard actually by the special bench. It was heard, but the order is awaited. It was heard in November 22, but order definitely is awaited. Uh, it might take some time, I'm not sure. So this is one which might come up. I'll just take the question. In the last case, the Uganda branch, can we not conclude that services are provided outside India? Uh, that is Dubai. So anyway, it was not taxable. Uh, yeah, services were provided outside India, but it was not provided to. It was provided to an Indian company only ultimately. So the payment that I'm making, I have to see under the India UAE DTAA because It's the Indian entity which is making the payment. If it was a separate entity outside of India, yes, then there is no question of Indian tax applying. But in this case, it's an income arising in India to the UAE entity. So, or the payment is happening from India. So when that is the case, then you have to apply. Uh, you'll have to see the taxability. Just a service being provided outside India would not get done or get you out of this scenario, because the service is ultimately it is provided to Indian entity only. So you will have to then take a close call. So now the next case is on is on place of effective management. So all of us are aware under Section 6 of the Indian Companies Act, for a company, um, a place of the place of effective management is where the company is said to be resident. This case pertains to assessment year 87, 88, 89. It was recently decided by the Supreme Court, which is the reason why I'm taking up this. So very recent, just a few days back. So before the substitution of place of effective management, because place of effective management is something now which has been defined. There are guidelines with respect to that. But prior to that, the language was during the year, the control and management of the affairs is situated wholly in India. So for a company whose control and management was situated wholly in India, it was considered as an Indian resident company. So if it's a company which is resident in India, the tax consequence is that the Indian taxes, whatever is there, those have to be followed, and the company has to pay taxes in India. Now, what happened is that in this case, so Mansarovar Commercial Private Limited. So you can see just 4 days back, this case was decided. So in the case of Mansarovar Commercial Private Limited, it's an interesting fact pattern, slightly, seems like history, is that when Sikkim became part of India only in 1975, and Sikkim had its own law applying even after it became part of India. Everything did not, suddenly all Indian laws applied to Sikkim citizen or people did not happen. So when the Indian Income Tax Act applied to Sikkim only for assessment year 1991 onwards. So at that time, I guess even 1 year assessment year was also not a sure shot requirement. It could be slightly more or low. So at that time, till 1 for 1990, Sikkim Manual 1948, which was like their income tax requirement, that applied. And in this case, the SSE was saying that it was carrying out business only in Sikkim, and it contained it till 31st March 1990. It was governed by Sikkim Manual and not by Income Tax Act. Why it is relevant is that uh, for this company, that is Mansarovar Commercial, it was held by or contended by the revenue is that the control and management of that company was wholly with their auditors who were resident in Delhi, so which is part of India. So for for income tax purpose, you will have to consider Sikkim as something which is outside of India. So for income tax purpose, since the revenue side, the control management of that company was wholly with the auditor here in Delhi, it became a resident of India, uh, and or for the income tax act purposes. Therefore, all its income, wherever it is earned, has to be taxed in India. And the argument was that no, we have always earned all the income in Sikkim, and the control management was not wholly with the auditor, and the all the books etc. were sent for audit etc. But in a search proceeding which was conducted on the auditor here in Delhi, it was all the books of accounts of there were 5 companies rather. Mansarovar was one of them. The lead matter, there were 5 companies like that. The books of accounts, blank checkbooks, signed blank checks, vouchers, etc. All of those documents were found with the CA in Delhi. So, which was the reason why everybody came to the conclusion that it was a CA from Delhi who was running the company. Therefore, the control and management of the company was in Delhi. So then reassessment proceedings, etc., continued on this company, and the matter there was first, stay, right, that there is no jurisdiction, etc. All of those ultimately got over, and the assessment happened. And in ITAT gave relief, but High Court said that no, it has to be taxed in India since the control management was in India. So Supreme Court now has held that head and seat and directing power of the affairs of the company, control management, it must be seen, from de facto. So what is actually happening is something that you should look at. So for in papers, for legally you can say everything is in Sikkim, but actually who has controlled the firm is something which is crucial, and we should look at the de facto control as to who controlled the management of the company. If it was the head and seat, the term basically is head and brain. If the control was in India, then you should look at, you know uh, you then it becomes a case of the company being domiciled in India, or company, which falls within Section 6(3) of the Indian Income Tax Act. Therefore, it has to pay taxes in India. Um, so, which basically is because of the control management being situated in India. So, this is an important concept for the reason now. Of course, we have something called place of effective management, but the hidden brain concept still applies. And if some fact pattern comes up which is similar to this case, then you might have to refer to this case law. So the next case law basically is a fallout of what we saw earlier. Um, it's the same transaction. Another issue is that all the income that Google Ireland is earning from India should be taxed, to the extent it is attributable to India, should be taxed in India, because the department contended that Google India is a dependent agent P of Google Ireland. Why a dependent agent P? Because it had all the right to sell the Google Ad service, etc. Therefore, it became a dependent agent P. But what the SSC contended that there is no obligation, or there's no empowerment uh, under the agreement that Google India can secure contract on behalf of Google Ireland. So what is important? So let's look at the P definition. It says that notwithstanding so and so, a person, uh, an enterprise shall be deemed to have a permanent establishment in the first mentioned contracting side in respect of activity which that person undertakes for the enterprise, if such person has and habitually exercises, if such person has and habitually exercises in that state an authority to conclude contracts in the name of the enterprise, so which is the other foreign enterprise. So has authority to conclude or habitually exercises the authority to conclude. So even if you don't have, if you are habitually exercising that authority, it still would fall within the realm of a dependent agent P. Now, if this was a fact pattern, the agreement in this case specifically, gave out a scenario that Google, or it did not empower Google India to enter into contract on behalf of Google Ireland. So that fact pattern itself, went in favor of Google, and it was said that Google India is not a dependent agency of Google Ireland; they function independently. So Google India is independent, works on a principal-to-principal basis. Therefore, you cannot consider it as a dependent agency. So we have our last case. I'll quickly, considering the time, I'll quickly summarize what this case is about. So this could be something which is of practical relevance, high practical relevance rather. We all, when we make remittances to a foreign party, we all take TRC, Form 10F, etc. Now, when we are taking TRC Form 10F, then all we look at is then, whether if there is a TRC, we take it as a conclusive proof, more or less, that okay, they are resident of that other state. Now, if you look at the statutory requirement under section 90, subsection 4, it says SSC not being a resident uh, shall not be entitled to claim a relief unless a certificate of his being a resident is produced. So a TRC is a mandate for claiming a treaty benefit. Similarly, Form 10F also should be provided. And on TRC, the Finance Ministry gave a clarification specifically saying TRC will be accepted as a evidence that he is a resident of that contracting state, and income tax authority in India will not go behind the TRC and question his resident status. So this is a clarification given by Finance Ministry on TRC by virtue of a press release. And for Mauritius specifically, TRC could be taken as conclusive proof. There is a specific circular, and that circular has been upheld in multiple cases. Azadi Bachao, Vodafone, Sanofi Pasteur, and a few more, where they have held that TRC would be conclusive, but that was with reference to Mauritius particularly. So now the recent case of Blackstone before Delhi High Court. So what happened is that Blackstone is a Singapore entity and it purchased shares of Agile Electric. So Agile Electric Sub Assembly Private Limited. So Agile Electric India, it purchased shares in financial year 13-14, and in financial year 15-16, it sold all the shares of Agile Electric to Igarashi Electric, which is another Indian entity. So Indian entity shares was sold to another Indian entity by a Singapore company. So the sale consideration was close to around 400 crores in numbers. Now reassessment proceedings were ultimately, while because the Indian entity was making a remittance of around 400 crore without taxation, because Singapore treaty does not allow. So if you look at this provision, Singapore treaty prior to 2017, uh, which was when this transaction happened, it read like this: capital gains. So this was from first clause was from immovable property sale, then movable property forming part of business, then alienation of ships and aircraft. The fourth clause says anything apart from this will be taxable only in that state. So where the seller is a resident. So now, if a Singapore entity sells shares, because shares is not covered in Article 1, 2, and 3, it was completely tax exempt. So similar to what we all know in Mauritius. So Mauritius treaty, similar position was there. Now, relying on this, no TDS was done, and the entity went ahead with uh, without making any TDS. Now there was a reassessment which was initiated based on this remittance information, saying the Singapore entity has not paid any taxes in India, and what was the apprehension was that it's not the Singapore entity, but it's the ultimate parent entity in US. Singapore entity was actually a special purpose vehicle, so it is the parent entity or the ultimate beneficiary is in US. And since India US DTAA does not allow any benefit, uh, you know, the benefit of Singapore entity cannot be allowed because the investment is routed through Singapore only to take the benefit of this DTAA provision is what was contended. And on behalf of the revenue, it was said that it's a shell company, etc., etc. Management is in US, and there's no capital gains exemption in that. And the way the investment also multiplied in 2 years, almost double, that also seems quite problematic. And then TRC, what was argued as TRC is not eligible condition for treaty benefit, but it is a it is only eligible condition. It is not a sufficient evidence of residency. It's not binding on any statutory authority. So that was the contention of the revenue. against that, so I've just pulled out the relevant clauses. So there was a LOB clause which was entered from 2017 that was also fulfilled in this case factually. So against that, what the court held is that revenue did not furnish any document to show that SSC is a tax resident. So if the revenue is saying that ultimately it's the US entity which is getting the money or which should have been taxed, then they did not prove any benefit. And the SSC, which was the actual seller of the investment, was incorporated in US. It was managed by its board in Singapore. So why I'm taking findings of the court is that it covers the arguments of the SSC. So not to repeat it basically. So since the seller was incorporated in Singapore and it was managed by board in Singapore without involvement of the founder who is ultimate beneficiary and was sitting in US, he is not involved in the affairs and management, etc. So just because there is an investment made from one country and further on, there is no necessity that you say it's only the ultimate beneficiary who has to pay tax. And nevertheless, if you look at the language, it nowhere says that the beneficial owner has to be it will be taxed in the hands of the beneficial owner. So taxed by resident of a contracting state if they are a beneficial owner. There's no such condition like that. So those conditions applied only to dividend. If you see India Singapore Treaty in dividend, interest, royalty, you will see beneficial ownership condition. But that did not apply to capital gains. So since for capital gains there is no beneficial ownership requirement, you cannot really get into this point and say this is required. That is one. And LOB clause was like it was there, it was satisfied. And revenue, what was important, that revenue cannot go beyond TRC as as a evidence for residency of a particular person for claiming the DTW benefit. This, if they go beyond TRC, it becomes, it becomes something where they are going beyond the assurance of the government, which is not allowed. So even though the assurance came through only by virtue of a press release, so what is important is that it's neither a circular or a notification; it's a press release. But the court held that even though that is the case, it's an assurance nevertheless, and TRC is where you should stop, and that should be the conclusive. So with this, I will stop my talk, and if there are any questions, I am happy to take it. And thank you for a very patient listening. I have overshot by a few minutes. Please, my apologies for that. And I'm happy to take any questions, any other comments, feedback, anything. So you can please raise your hands if you have any questions. So if there are no questions, then I give it back to Rishikesh ji.
Yeah. I hope we have answered all the questions of the.
Yeah, the attempt was to answer as we progress.
Right. If the participants are clear, then let us conclude the seminar.
Yeah, even otherwise, if there's any query, feel free to make. I'll be happy to answer.
The faculty has shared his email address also. If there are any queries from the side of participants, they can very well mail the queries to the email ID given.
Sure.
So once again, I thank CA Vasudevan for his excellent session covering all the case laws, recent case laws. He very well delivered MFN clause also. I was listening to that on silent mode.
Thank you.
Thanks once again. And I also thank all the participants who have joined all the 10 sessions and patiently listening to all the sessions. Keep visiting the Pune ICAI website for more and more seminars. once again, thank you. Let us
Thank you very
conclude.
much.
Thank
Thanks.
you.